All right. Hi, everybody. Welcome to today's webinar on the Cap-Exempt H-1B option. My name is Katherine Del Rosario. I'm an attorney at McEntee Law Group here in Chicago. I practice both family and employment-based immigration, and Cap-Exempt H-1Bs are some of my favorite cases to work on. They usually require a bit more creativity than your standard H-1B, but it can be a pathway for someone to live and work in the United States when they've exhausted all other options. If you have any questions during the webinar, please enter them in the Q&A section so I can answer them at the end. Okay, just a note, as always, this webinar is meant for informational purposes. Always contact an attorney about your specific situation, and the processing times that I will mention later on in the session are based on USCIS's estimates as of today, September 2023, and these are subject to change. Okay, we have a lot to cover today, including what does cap exemption mean and how does it differ from the cap subject H-1B? What is required of an employer to be considered cap exempt? Which jobs and which workers qualify? How does the application process work? And then I wanted to highlight some special opportunities for cap exempt employment at the end. This is just a review of the H-1B generally. The H-1B visa is a non-immigrant visa program that allows a U.S. employer to temporarily employ foreign workers in specialty occupations that require at least a bachelor's in a specific field. The H-1B is valid for 3 years. It can be extended for an additional 3 for a total of 6 years in H-1B. When someone's approaching that 6 years, we say that they're maxing out. Under the regular H-1B program, first-time applicants must enter the lottery, which is a random selection process to allocate that year's H-1B visas. The number of visas is limited or capped at 65,000, with an additional 20,000 for individuals who earned their master's degrees in the United States. So that's where the term cap comes from. It's from the annual limit. This past cycle of the lottery had 2 rounds of selection, and the data that was released after the lottery shows that about 15% of eligible registrants were selected. This is lower than previous years, so it just shows that it's such a competitive process and can be very stressful because the number of registrants usually far exceeds the number of available visas. And so you may find yourself in this boat, and that's why you signed up for this webinar. So if you weren't selected this year, we would like you to consider the cap-exempt H-1B as an option. The cap-exempt H-1B is not subject to the annual cap, and it's available to these categories of employers: institutions of higher education, a nonprofit related to or affiliated with an institution of higher education, or a nonprofit or government research organization. And we will dig into what each of these employers looks like. Okay, with the first, an institution of higher education, typically a college or university, it must be accredited by a nationally recognized accrediting agency, must be public or other nonprofit, and licensed to provide post-secondary education and offer a bachelor's degree or no less than 2-year programs that count towards a degree. Now, when you think of a private university, you might not think that they are considered nonprofit, but that's actually usually not the case. So most schools, I find, most mainstream schools do qualify under this definition, but you'll want to double check their accreditation and their nonprofit status, which are usually publicly available. A nonprofit related to or affiliated with an institution of higher education. This is our second type of cap-exempt entity. So let's break down the definition. It must be approved by the IRS as tax exempt for research or educational purposes and related to or affiliated with. Now, that can be demonstrated in a few ways. So shared ownership or control by the same board. If the nonprofit is operated by the university or attached to it as a member, branch, cooperative, or subsidiary. Or is there a formal affiliation that establishes a working relationship for research and or education? So it must be a fundamental activity of the nonprofit to further the education mission of the institution of higher education. So some examples of this would be like a hospital or medical research organization. From my own work, I did a Cap-Exempt H-1B for a teacher in a private school, and the private school had an affiliation with a local university. So the agreement was that the university's teaching students, so their education students, there was a formal agreement to place those students in the private school's classroom to gain teaching experience. We were able to show, a written agreement explaining the relationship, and that worked for a Cap-Exempt H-1B. Okay, and then the research organization. There are two types. There's the nonprofit research organization and the governmental research organization. The nonprofit must be primarily engaged in basic or applied research in the fields of science, social science, or humanities. So basic research can be thought of like the gathering of information or data. And then applied research is research that uses that data to find answers or solutions. I find that applied research is more common in organizations. So let's say, an organization is taking data from the classroom and then using it to inform public policy decisions. That would be a great example of applied research. Governmental research organizations are entities whose primary mission is to promote basic or applied research. So some examples of this would be like the CDC or the FDA. Okay, now we look at proving Cap-Exempt status. So how do we show that your employer is truly Cap-Exempt? These are the most common documents that I would request from a petitioning employer. The incorporation documents, how they're set up in the state with the IRS. These can show the organization's tax exempt status. It can show their research purpose because often the mission is laid out in the incorporation documents. It can also show the shared ownership between the two entities. Memorandums of understanding and formal contracts can show the affiliation between the nonprofit and the institution of higher education. It can show that working relationship and often can provide a lot of the detail about how the relationship furthers the education or research mission. Organizational literature. So this can be a lot of things, but basically it's showing the research mission and activities of the organization. I'm thinking of like annual reports, or that you would give to your supporters, to your board members, or even grant applications. So if the organization is applying for funding for the purpose of completing their research, that is a great document to have because it's making the argument really of how committed to the research purpose you are. And then research product. So these, again, could be like the annual reports that an organization puts out every year, kind of showing what they've been working on. This could be white papers. I have one example in mind of an organization that was committed to preserving people's stories, and they did that with mixed media. So they had a lot of video, photos, and audio. And this was wonderful to kind of reach a younger audience. But as you probably know, you can't submit videos or audio to USCIS. And so the way that we were able to show their research product was by using the transcripts of these recordings as proof of the research that they had done. The Cap-Exempt H-1B must meet the other requirements of the H-1B generally. It has to be a specialty occupation, requiring at least a bachelor's in a specific field. The applicant has to have that bachelor's in the related field, and the employer must still agree to pay the prevailing wage for that occupation in the intended area of employment. So whatever city that that person is going to be based in, employer must agree to pay that prevailing wage. So these parts of the H-1B, the Cap-Exempt H-1B don't change. However, under the Cap-Exempt rules, there's like potential for, there's an exception that I wanted to note here. A for-profit company could potentially hire a foreign national to work at, but not for, a Cap-Exempt employer. So this would look like a regular schmegular for-profit company hiring someone to, say, work at a hospital or medical research facility. I think this arrangement is a little more rare, but I have seen it. There are reasons why a company might want to do that. Maybe they're a biomedical research company that's for profit, and their potential employee just wasn't selected in this year's cap, and so they still need them to do the work and do the research, and so they could have them do it at a cap exempt entity such as hospital or medical research facility. Again, more rare, but it is possible. The advantages of the cap-exempt option are quite significant. As you can imagine, a petitioner could file the case anytime of the calendar year within 6 months of that person's intended start date. There is no need to enter or be selected in the lottery, and premium processing is available, meaning petitioner or beneficiary could pay the extra $2,500 and get a response from USCIS within 15 calendar days. The application process for the cap-exempt H-1B essentially mirrors that of the regular cap subject H-1B, except for time of the year. So normally, the lottery happens in March. We find out by the end of March if you've been selected, and all cases that are filed and approved, that person moves into H-1B status come October 1st. So that is the normal cycle of H-1B, of cap subject H-1Bs always. But here it can happen any time of the year. The steps are the same, save for the actual lottery process. So first, the Department of Labor must issue the labor condition application, or the LCA, showing that the employer agrees to follow all the H-1B rules, including paying the prevailing wage. The cap-exempt case is filed with all of its required fees, forms, and supporting evidence. I would note that the fees are a little bit less for a cap-exempt case. And then USCIS processes and adjudicates the case. As of today, September 2023, USCIS is taking about 2 to 4 months to process H-1B cases under the regular timeline. But if, as mentioned, if premium processing is included or added on, then you get that response within 15 days. Okay, I wanted to highlight these two very unique initiatives that our firm has worked with. One is Open Avenues, and the other is Global Detroit. So the H-1B rules allow for potentially multiple employers to file concurrent H-1B petitions for the same person. And the model for Open Avenues in Global Detroit essentially works like this. A partner university would file a Cap-Exempt H-1B on your behalf to work part-time. That part-time employment would involve providing leadership and real-life learning experiences and training to students. But once that Cap-Exempt petition is approved, then a full-time employer, for-profit, your own startup, what have you, could file a concurrent H-1B on your behalf. The hope is that, international entrepreneurs would be able to work on their business while also contributing, to the education and experience of other students. I think this is a super cool way to utilize the Cap-Exempt option. Open Avenues, I believe, has partner universities all over the United States, while Global Detroit, as the name suggests, is really Michigan focused and really looking to build up business in the Detroit and surrounding area. Okay, we went a lot quicker than I anticipated. So I'll open it up to any questions that you might have. I will say that, in working with Cap-Exempt cases, they, as I mentioned in the beginning, tend to be a lot more tailored and require more creativity, because I'm needing to get to know the ins and outs of the organization. How is it that they perform and produce research? What is it that you can show me to demonstrate this? And so I think it requires a lot more participation from the petitioner and the beneficiary to really get a Cap-Exempt case across the line. Okay, I am looking to the Q&A. Let's see. Can the H-1B be applied for by an individual rather than an employer? So in short, no, it has to be an employer that files the H-1B case. The main reason being that one of the requirements is that there's a valid employer-employee relationship. We work with a lot of startups though, where there's like a staff of 2, or maybe not even a paid staff yet, but they're working on that, and startups can file H-1B petitions for their workers. It's very, very possible. We've done it, so I hope that's not a deterrent. Do we need to find out the institution or organization your group has worked with some? I wonder if you're referring to Open Avenues and Global Detroit. So we're not our firm is not formally affiliated with them, but we have worked with them in the past, and they are presenting such unique opportunities that we wanted to highlight it here. But we're happy to connect you with them, or you can contact them directly. I think with Open Avenues, the way that they kind of kick things off is to interview both the potential beneficiary and a petitioning company. So if you're working for a company and you haven't been selected in the lottery, they can kind of nominate you for an Open Avenues fellowship. What is the process of switching over to a for-profit job while under the cap-exempt H-1B through a university? Can you still stay on cap-exempt H-1B if the lottery application fails? This is a wonderful question, and I'm sorry I didn't address it in my slides, but while it's a huge advantage that you're not subject to the lottery if you file a cap-exempt case, if you were to switch employers and it was a for-profit company that cannot, qualify as cap-exempt, you would then have to enter the lottery, I mean. However, if you were to switch employers to another cap-exempt entity, then no need to enter the lottery. You would file a straightforward transfer to the new cap-exempt company or cap-exempt organization. In both instances, though, you are still subject to the 6-year maximum. So whether you're under cap-exempt or cap-subject, your current petition will be valid for 3 years and renewable for another 3 with a maximum of 6. There are exceptions to that. So if at some point you start the green card process and you reach a certain point, what I'm thinking of is the I-140 petition, so the immigrant petition. You would then be able to extend your H-1B beyond the 6 years if you have that approved petition. Is it common to have a cap-exempt applicant who previously applied with a cap-subject company? I've seen it. I would say it's not as common, but it's possible, very possible. But I would note, just as I did during the last question, that employment with both types of entities still counts towards your 6-year maximum in H-1B status. Can we also work for some other company as full-time? I'm going to assume again that this is under the scheme of like the Open Avenues or Global Detroit arrangement. So if once the university has filed the part-time concurrent H-1B, cap-exempt H-1B for you and it's been approved, then a separate company who's not typically cap-exempt could file a full-time petition on your behalf. It would still be concurrent, but it could be for part-time work or full-time work. However, you'd still have to comply with the terms and conditions of your H-1Bs. So if it's work outside of the university or work outside of that second employer, then it's not allowed under the H-1B rules. Do we all do similar processes that what Open Avenues is doing? We partner with Open Avenues on their initiatives, but they're really the ones spearheading the cap-exempt program. So it's not something that we are leading per se. They have built up quite a system and a network of universities that is very supportive of this program. So we ourselves aren't doing that in-house. Here, I thought there were no questions. I'm so glad. Okay. How does the green card process work during the H-1B process? Okay, so the green card process, which we typically call PERM, can work, it can be started at any time. So even if you have never had an H-1B, but your employer does want to start the green card process for you, they can. How long it will take depends on a few factors. The main one that I'm thinking of is what country you're from, because depending on where you're from, your country may have a backlog of visas. Probably the longest, the most infamous are the backlogs for China and India. So if you take the backlog out of consideration, for all other countries right now, the green card process from start to finish, I would say is taking about 3 years. And the actual change in your status doesn't come until the very end. There's a lot of preparation work, a lot of compliance work that we have to do with the Department of Labor leading up to your green card. And so you have to maintain some other kind of status in the meantime if you're going to stay in the United States, which is why most folks are on H-1B while their green cards are going. But that might not necessarily be the case for you. You might be abroad and your employer is working on your green card. You might be a student. It's more rare, but it's possible. Or you might be on some other type of visa like L or TN. Open Avenues also does something for employees, not necessarily just the startup. If you can clarify your question, I'm happy to answer. If I were to guess, I would say, how does this program kind of impact or benefit employees? I think who Open Avenues might have in mind is our entrepreneurs that may be working on their own startup. And so they are both the employee and also part of the startup. Can a Cap-Exempt employer apply for a green card after 2 years on H-1B? I hope you heard the question 2 questions ago. Green cards can be started at any point. So, but I think what I usually see is that an employee will be in H-1B status for a couple of years, and then as they are kind of approaching that 3rd year, the employer will decide whether or not they want to pursue the green card. So that's kind of the common timeline, but there's nothing in the rules that says you have to be on H-1B for any amount of time at all before starting the green card process. It can be started at any time. If I'm to consider H-1B or national interest waiver, which type of visa would provide a better option, especially in terms of changing employers, states, etc.? Can an NIW be filed by an individual be granted? So these are totally different visa types, both with their own kind of set of criteria. I would, full disclosure, NIWs is not something that I personally work on every day, but our firm does. But I would liken an NIW to an O visa or an extraordinary ability visa, where there are some pretty high criteria, high standards that you have to meet in order to qualify for a national interest waiver. And so potentially an individual could be granted, and I think the criteria, though, the set of criteria is truly just different, but the H-1B is very much location specific and employer specific. But if you're considering both, or maybe you're even considering the O, I would definitely contact our office to talk through that. I'm not in the best position to advise on an NIW, but good question. Just two very different visas. I have a question on the entrepreneurship slide. Does that mean we can have our sponsorship from part-time employer and parallel work on our own startup? Yes, that's the beauty of that program, is that, and as I understand, the commitment to the university is pretty minimal. I know under Open Avenues, it's a 5-hour commitment that could potentially be remote. So you have the rest of the time to work for your full-time employer, whether that's a separate company or your own startup. Okay, so this person's asking, I need the Cap-Exempt H-1B to work for a tech company since I was not selected. What will be the timeline or process for this? Will I transfer the Cap-Exempt H-1B to the tech company? So if we set aside the Open Avenues and Global Detroit options, because those are those are kind of a separate thing. In just looking at the Cap-Exempt H-1B option, your employer has to qualify as Cap-Exempt. If your tech company is not a nonprofit research institution or not a governmental research, organization, then if they don't have an affiliation with a university, then they wouldn't qualify as a Cap-Exempt entity. So they could not petition your H-1B. You would have to wait until the next cycle, so next March, to try again. And let's just say, for argument's sake, that your employer was a Cap-Exempt entity and you were able to get the Cap-Exempt H-1B now, because Cap-Exempt cases can be filed any time of the year, right? Within 6 months of your start date. Let's say we were able to do that, but then later on you wanted to transfer to a for-profit tech company. You would have to enter the lottery. You can't switch from Cap-Exempt to Cap-Subject without entering and being selected in the lottery. So just another follow-up. So an individual who got Cap-Exempt H-1B through their nonprofit employer then changes to a for-profit employer. You'd need to have their new company reapply for H-1B, therefore now being Cap-Subject. So just to reiterate, Company A is Cap-Exempt, and Company B is Cap-Subject. If you want to move from A to B, then Company B has to enter you in the lottery, you must be selected, and then they must file the H-1B Cap-Subject case on your behalf. If you have the Cap-Exempt H-1B through Open Avenues, I can still work for the tech company. Theoretically, yes, under that program, if you're accepted, you would work part-time for a university through Open Avenues, and then the tech company could petition you for an H-1B. I think I understand your question now, so I'm sorry if I didn't address it earlier. Under this scheme, under the Open Avenues arrangement, your employment with the tech company can only exist, concurrently with the Open Avenues Cap-Exempt H-1B. That's how it works. If you were to, I think, work fully for the for-profit company, then you'd have to enter the lottery. The person who switched from Cap-Exempt to Cap-Subject still has the 6-year limit running. The timer doesn't restart. No, it does not restart. So any time spent in a Cap-Exempt company or a Cap-Subject company all goes towards your 6-year limit. And the H-1B from the tech company, we do not need to go into the lottery. If you're going through the Open Avenues route, then no, you do not need to enter the lottery. That's true. I knew we'd get a lot of questions about this because it's such a unique thing. So I really encourage you to contact them to find out more information and see if you'd be a good fit. I'll hang around for a little bit more to see if there's any more questions that roll in, but as like a special gift to everyone who attended today's webinar, we're offering a $50 discount on our Cap-Exempt H-1B consultations. It would be either with myself or my colleague, Dan, who also works on this type of case. So if you're interested in exploring this option further, whether it's with your own employer or maybe through Open Avenues, or if you're in Detroit through Global Detroit, please contact our office to schedule a consultation. We'll be happy to talk about it in more detail. A final question here. So to conclude, we need to work for Open Avenues as part-time and work for tech company as full-time. In short, kind of. So Open Avenues is coordinating this whole thing, but the university that you're partnered with, you'd be partnered with through them, would file the part-time concurrent H-1B, and then your company, the tech company, could either file a part-time concurrent or full-time concurrent H-1B. Okay. I think that's all the questions. Yes, the session will be recorded. We'll post it to our socials, and here they are. Follow us on Instagram, Twitter. Our TikTok is really fun. Our LinkedIn and our YouTube as well. So yes, this webinar will be recorded and posted on our website. Thank you so much for joining. Again, as I said, this is one of my favorite types of cases to work on. I work more closely with clients on this, and like I said, requires a little more creativity here, but it's truly one of my favorites and definitely a good option if you've exhausted all others and aren't sure where to go from here. So thank you so much for joining us, and take care. Bye-bye.